Here to provide a century's worth of compliance advice are Tom Hudson, partner with Hudson Cook LLP, Terry O'Laughlin, Director of Compliance with Reynolds & Reynolds, and David Robertson, Executive Director and co-founder of the Association of Finance and Insurance Professionals. Please give them all a warm welcome.
Thank you all for joining us today for our presentation, A Century's Worth of Compliance Advice. I'm joined by two distinguished colleagues who have a combined experience with compliance law of over 80 years, and I have almost 30 years of compliance experience. Tom Hudson to my left is a founding partner of Hudson Cook, and to his left is Mr. David Robertson, Executive Director of the Association of Finance and Insurance Professionals, AFIP. And I am Terry O'Laughlin with Reynolds & Reynolds, the Director of Compliance. So collectively, we have over 100 years of compliance advice to share. Now, ladies and gentlemen, this is what's called a disclaimer. You cannot rely upon what we're telling you today, but we assure you we're telling you the correct truth, the absolute truth, but you should seek your own legal counsel to verify what we have to say. Now, the next slide speaks for itself. So please read it, contemplate, and ruminate over its implications from Scripture. Okay, let's move on. We're going to be reviewing today the great arc of compliance law in a breakneck speed, like a bullet train. And we're going to be reviewing the law itself. Mr. Hudson is going to address the law, explain it. I'm going to address the issues surrounding that law that affect dealers. And Mr. Robertson is going to handle the remedies. He's going to explain how to resolve this. So to begin, let's look at the chronology, the history of all the laws. In 1812, believe it or not, this War of 1812 spawned the law that proscribes the American business working with foreign interests. Today, the SDN issue.
In 1914, along comes the Federal Trade Commission Act. This was the federal law that created the Federal Trade Commission, which is your top cop in Washington, D.C. for compliance issues. In 1926, 12 years later, along comes Congress with the Federal Arbitration Act. That's the law that gives you the authority to enter into agreements with your customers to arbitrate disputes, a good way to head off class action lawsuits.
1958, Senator Maroney from Oklahoma, he championed the bill which passed that for the first time, the MSRP had to be posted on cars.
And speaking of class action lawsuits, in 1966, along comes a fairly obscure federal court rule. The modern class action is governed by Rule 23A of the Federal Rules of Procedure. That was passed, gave room for plaintiffs' lawyers across the country to sue all kinds of businesses, including car dealers.
1968, the Truth in Lending Act, Regulation Z&M. It established APR as the method for disclosing the cost of credit, and it established mandated disclosures.
And in 1970, the Fair Credit Reporting Act was passed, which addresses using credit reports, obtaining and using those reports, and the adverse action notice had to be provided.
And in 1972, we get two for the price of one. That was the year the IRS came out with their Form 8300 cash reporting rules. Fairly simple concept, but it gets awfully complicated to comply with. And that's the year that the Federal Odometer Act came out to combat odometer fraud.
1974 saw the Equal Credit Opportunity Act, Reg B. It addresses discrimination in credit in all forms.
Once again, in 1975, the Madison-Moss Warranty Act was passed, which addresses written warranties. In the same year, the Holder Rule was passed, which means disclosure must be provided to consumers and to provide their remedies if the vehicle is sold and financed.
1985, remember now, these are rules, but remember these rules have the force of law just as if they were enacted by Congress. We get the used car rule from the Federal Trade Commission, also the credit practices rule from the Federal Trade Commission, both bearing directly on your transactions with car buyers.
In 1991, we have the do not call, do not fax, do not email to protect consumers from unsolicited advertisements.
Then in 1999, the Gramm-Leach-Bliley Act was passed, which produced the safeguards rule and the privacy rule.
In 2008, we get the red flags rule. A lot of people think that red flags has something to do with privacy. In a sense it does, but it's really an anti-identity theft measure.
In 2010, we had the Dodd-Frank Act, which gave us the CFPB, and they're kind of everywhere.
And then there are all the state laws, which track federal laws, and particularly the Unfair and Deceptive Acts and Practices law, UDAP, and RICO, Racketeering Influence Corrupt Organizations Act. But they all were passed along the way with all the federal laws.
Okay, here we go. We want to talk for a minute about the laws and regulations that we see that primarily precipitate investigations and legal causes of action. Terry, you want to fill in the detail on that? First off, there are state unfair acts and practices laws. These are called UDAP, Unfair and Deceptive Acts and Practices laws. Nearly every state has them. The Federal Trade Commission Act is essentially the federal corollary of those state laws with a couple of interesting distinctions. The Truth in Lending Act, Regulations Z and M, as Dave pointed out, are requirements by the federal government about how to disclose credit extended to consumers. State Retail Installment Sales Acts deal with the terms and conditions of the credit you extend to consumers. And the federal Gramm-Leach-Bliley Act and its safeguarding rule and privacy rule requirements deal with how you handle customer information.
All right, let's talk a little bit about the used car rule. Its purpose is to make sure consumers are aware of either the presence of or absence of warranty protection, and has other provisions as well. The Equal Credit Opportunity Act, Reg B, as we talked earlier, then deals with discriminatory practices in the granting of credit. Credit Practices Rule governs cosigners, and it talks about what you can do on other areas of credit as well. The Dodd-Frank Act, Consumer Protection Bureau, speaks for itself. The Office of Foreign Asset Control, the old-timer, makes sure that we don't do business with people who are on the specially designated nationals or block persons list. And then we have the Federal Arbitration Act.
You, Terry.
Yep. Furthermore, we have other laws such as the Automobile Information Disclosure Act of 1958, the Monroney label, the Fair Credit Reporting Act of FACRA, and the federal do not rules such as do not call, the Telephone Consumer Protection Act, the do not fax, the Junk Fax Prevention Act, and the do not email, the Canned Spam Act.
And those are followed by the Federal Odometer Act, the Form 8300 Cash Reporting Rule, that Modern Class Action Rule I talked about a few minutes ago, the Federal Trade Commission's Holder Rule. That's the rule that gives consumers the right to sue any holder of a retail installment contract for claims they might have had against you, the dealer. The Magnuson-Moss Warranty Act, which imposes restrictions on your transaction with the dealer as far as warranties are concerned. The Federal Patriot Act, an anti-terrorist act on the part of the federal government that ropes in dealers for some duties. And the FACTA Disposal Rule, which sets forth how you have to go about disposing of certain consumer information.
Now let's consider what government agencies are the most likely to take action against dealers. By far and away, the most significant one is the State Attorney General, who has both the authority, the motivation, and the manpower to take action against dealers. Coupled with that are the DMV and other state agencies, which generally refer their cases to the Attorney General. Now, the FTC is also formidable. However, it does not have the manpower that the state Attorney Generals have. And the CFPB, well, the really good news, the NADA was able to get dealers extricated from the direct jurisdiction of that bureau. And finally, the Department of Justice, DOJ, rarely does it take action, but when it does, it takes significant action against a particular dealer.
Okay, to this point, we've just been enumerating laws and giving a brief thumbnail sketch of what the law does. Now we want to have a little bit of a deep dive and put some meat on the bones of what these laws require. State unfair and deceptive acts and practices, or UDAP laws, are in almost every jurisdiction. They basically prohibit dealers and other merchants from engaging in bad acts and practices with consumers. The definitions they use are fuzzy. Plaintiffs' lawyers love that because they can claim that almost any actions that seem to be improper would violate one of these laws. Once they make that claim, most of these laws permit a plaintiff to recover some multiple, twice or three times the plaintiff's actual damages. and they also permit a plaintiff to recover attorney's fees. So that's why these laws are a favorite of plaintiffs' lawyers all over the country. Lawsuits that deal with things like bait and switch and payment packing and spot delivery and things like that are almost always involve at least one claim that those practices violate a UDAP law. The Federal Trade Commission Act, think of the Federal Trade Commission Act as a UDAP law at the federal level with one distinction. The Federal Trade Commission Act is enforced by the government. It doesn't give consumers a private right of action to sue a dealership. But it's bad enough to have the FTC on your case. The FTC Act is the authority for all the enforcement actions that I can think of that you've read recently by the FTC against dealers, things like spot deliveries and advertising especially. The Truth in Lending Act, the Consumer Leasing Act, Regulation Z, Regulation M, these are all federal disclosure requirements. The federal government, the way I think about the difference between the state and federal government is that the federal government doesn't much care how much interest you charge, how much your finance charge is, how high your APR is, how much your late charge is. Federal government doesn't care. What they say is, if you're going to charge these fees and charges, you have to disclose them in precisely this way. So federal government is precise disclosure rules. In order to get to the governing of things like the maximum APRs and whatnot, you have to turn to state law. Almost all states have a Retail Installment Sales Act or something like that, and those acts tend to say the maximum finance charge you can charge is this, the maximum late charge you can charge is this. There are limitations on your right to repossess if there's a default, things like that. Those issues are addressed at the state level by a state Retail Installment Sales Act. The Gramm-Leach-Bliley Safeguards Rule and Privacy Policy, this is old enough now so that all of you should have in your dealerships a written privacy policy. You should have named a privacy officer. You should be handing out copies of your privacy policy to your customers. Your privacy officer ought to be reviewing your safeguards rule periodically and making sure it's up to date and still doing what it's supposed to do. A good idea, a good tip, by the way, is to take that privacy officer and combine that person with make that person also your red flags officer, make that person also your compliance officer.
Okay, moving on. Let's identify the kinds of issues that dealers face and the problems that they might create for themselves. For example, the UDAP Act, Unfair Deceptive Acts and Practices, payment packing, fraudulent spot deliveries, failure to credit the cash, the coupons, the trade-ins correctly. The Federal Trade Commission Act, FTC, once again, payment packing, false advertising, mercenary sales. And the Truth in Lending Act, TILA, under Reg Z and M, failure to track agreed upon terms, misrepresenting the mileage limitations, finance charge abuse, and inaccurately portraying the trade-in values. Moving on to other ones, the State Retail Installment Sales Acts, the failure to observe the interest rate calculation, APR error calculations exceeding the maximum rate, or the privacy rule, moving on to the Federal Gramm-Leach-Bliley Act, failure to provide the notice itself, using a privacy notice which doesn't reflect the dealer's organization. Remember, there are over about 288 different versions of the privacy notice. The safeguards rule, failure to implement an information security program, failure to appoint a compliance officer, as Tom referenced, failure to implement and enforce and update, very important, updating your identity theft program. And finally, failure to simply lock your files in a secure place. And with that, Dave's going to address the remedies for these issues.
I want to preface my risk mitigation discussion with the following. First, I want you all to understand that I know in the middle of all this regulatory stuff, we still have to sell some cars. And I've sold cars, and you can't sell a car and effectively make a sale without knowing the benefits and features of that vehicle. The same holds true for the people who execute binding legal contracts on your behalf. They must be conversant with the state and federal regulations that govern those contracts. Incidentally, in the range of about 90% of the people in your store who are asking customers to sign those binding legal contracts have never read them. Now, simply telling your people to read those contracts is a waste of time. However, by printed directive, you need to instruct each sales, desk, and F&I person to take a sheet of paper and write down what they think the covenants on the back of an installment sales contract mean. They put their name on it, staple it to the contract, give it to your controller or office manager for a critique to find out what they really mean. Then do the same things for lease agreements, vehicle service contracts, GAP, and etc. If you do, two good things will happen. First, you'll reduce the number of consumer hassles and PR claim payments. And second, your people will sell more stuff. There are great selling points buried in the covenants of those contracts. You know, many times it's the simple things that have the greatest impact. Next slide, please. Let's talk about payment packing. And I'm familiar with this one. Before flying to New Orleans, I submitted an expert witness report on this topic. Now, there are numerous definitions as to what payment packing means. I use the one that's used by the National Association of Attorneys General. Packing is a deceptive practice of misrepresenting monthly payments to customers during auto sales and lease negotiations to facilitate the sale of automobile-related products or services. Now, packing can be an inflated APR, a truncated term, or just simply quoting a monthly payment that's been overstated. Now, we need to keep in mind that buying a car is one of the few remaining negotiated transactions in the United States, and some latitude has to be accorded the buyer and the seller. But let's get down to payment packing. Number one, in your store in writing, you need to have a policy that says payment packing is not permitted. Number two, the APR quoted on the first pencil quote before the customer's credit score is known needs to be commensurate with something. The use of a set of higher than the norm's APR to cover most credit scores can get you in trouble. Whether intended or not, an inflated APR creates a leg at the onset. 3, generate your first pencil payment quote factors based on the average new and used car APRs charged in your store on a 60 or 90-day running average, factoring out any zero APRs. These rates are statistically verifiable and commensurate with the situation relating to your store and clientele. The customers are told that the monthly payment quoted was based on the average APR for your store, and that his or her cost of credit will be higher or lower depending on their credit worthiness. 4, set markup thresholds on the origination reimbursement fee, which we know is a markup over the buy rate, and all aftermarket products. 5, monitor the consummation documents to ensure full disclosure and the customer's awareness of and signed acceptance of aftermarket products. Your deal recap sheet needs a good look. What we're checking for here is incidences of payment packing. 6, fire the first person you catch packing payments. Next slide, please. Let's look at FTC risk mitigation. Let's talk about false advertising. The rules governing advertising are addressed at the federal level by the Federal Trade Commission, and there is plenty of guidance available from the FTC, NADA, and others. Your state regulators have their own set of advertising requirements. That information is usually available from your state dealer association, and they have handy guides as well. But what constitutes triggering and trigger terms is precise, and when applicable, what is deemed to be acceptable or prohibited language in an advertisement is clear. Next step, number 1, make certain that the person responsible for pitching the ads is cognizant of the prevailing regulations. I'd hand them a copy of the guides that are applicable to your market. 2, I know it gets boring, but religiously read, watch, or listen to your own ads. What are they telling people in these ads? Number 3, reassign the person who habitually runs misleading ads. Quick word on mercenary sales. It is a personal opinion, but I don't believe a mercenary sales campaign serves any dealership well in the long run. Good sales practices carry the day, and you don't need a bunch of outsider hotshots with no long-term ties to your store or your customers selling your cars. As the slide shows, mousing entries on agreements or misrepresenting to customers what's on those agreements is a bad thing to do. Are we on Slick 16?
Yes.
Yes.
Let me talk about a fair number of Reg Z and Reg M hassles that can be eliminated by just having knowledgeable people disclose them to your customers. Again, having people that know what the rules are is a good first step. Let me give you a quick example. The total sales price is always the largest number on an installment sale contract. If the customer asks a question during disclosure, this is it. An Elmer Fudd ba-da-ba-da explanation or an accurate one causes the customer to distrust the process. A sharp F&I person will say, "Sir, your total sale price reflects your total investment in this vehicle. You paid $6,000 cash down, sir, that's your money. You had $4,200 positive equity in your trade-in, that's your money. And you're going to pay $42,000 worth of payments to Ford Motor Credit. Sir, that is your total investment in your vehicle, that is your total sale price." Let me give you another risk mitigation tip, and one that is in compliance with Reg Z. Your F&I manager should hand the installment sales contract to the customer before you disclose it. What happens is we get into court, they'll put that installment sales contract up on the screen, they'll ask the customer, "What's in that agreement?" The customer will say, "I don't know, they went through it like Sherman did in Atlanta and told me to sign it in 6 spots. I don't have a clue of what's there." Poof, it's gone. But if your F&I manager hands that contract to the customer and says, "In a few minutes I'm going to disclose this, please take some time and look it over." You then ask an open-ended question. "Sir, what part of this contract would you like me to disclose to you? Do you have any questions?" "No." Then you take it back and disclose it. Now when we get into court, we'll ask the customer, after the F&I person handed you that contract, to review, did you have any questions? Makes a big difference. Next.
Okay, it's my turn again. Terry, if you'll put the detail up there for us.
Sure.
We're going to go through another set of rules and laws. Again, I'll give a brief explanation of the laws, and Terry will point out the problems, and Dave will point out the risk mitigations. The used car rule, you're all generally familiar with this, I know, because on your lots, all your used cars have the window sticker in them. That's the federal requirement. If a car is offered for sale, it has to have a window sticker. There are other parts of that rule, though. There are requirements for what goes in the window sticker. There are contract disclosures in your contract of sale that are required to be included. They have to be conspicuous. Very often I look at buyer's orders and they're not. If you negotiate transactions in Spanish, there have to be Spanish language buyer's orders in the cars, and there has to be a Spanish language translation of the contract language. The Federal Trade Commission is fond of sending out SWAT teams from their field offices to go to various markets and land on dealers and prowl around the lots and then bring charges for failure to comply with the FTC used car rule. You may have heard recently that the FTC has recently revised its used car rule. There are some difficulties with the lawyers are finding with how we're going to comply with those. Before you start using them, you need to have a sit down with your lawyer. The Equal Credit Opportunity Act in Reg B, this is that federal law, remember, that prohibits discrimination in any aspect of credit based on certain prohibited bases, such as race and marital status. This is the law that the CFPB relied upon when it went after the finance companies and banks for those high-profile, high-dollar fine race discrimination cases a couple of years back. The Federal Trade Commission credit practices rule is not something you're likely to ever stumble over. What that rule does is require and prohibit certain terms and conditions in your contract of sale and your financing contract with your customer. Those problems have generally been addressed by the forms companies that put those documents together. So for the largest part, you don't have to worry about those, except that Dave will mention some cosigner problems that pop up. OFAC, this is the bad guy list. There's no federal law that says you have to check the bad guy list, the designated persons list maintained by the Office of Foreign Assets Control. The law doesn't say you have to check the list. What the law does is prohibit you from doing business with anyone whose name is on that list. So the way you avoid doing that is to check the list. And again, Dave will talk about the use of a little bit of common sense in figuring out whose backgrounds you're going to check. The Federal Arbitration Act is now nearly 100 years old. I said earlier it was put in place to permit private parties to agree to settle their disputes someplace besides the courthouse in front of a neutral arbitrator. Over the last 15 or 20 years, car dealers have adopted the practice of including mandatory arbitration agreements in their transactions with consumers. Consumer advocates and folks like Legal Aid have been railing that that's a terrible thing, and they've convinced the CFPB to propose a rule that will prohibit certain kinds of arbitration agreements. If that rule is passed, then this industry and others will lose the ability to use arbitration to blunt class actions. That'll be a bad thing. Whether or not Trump's prohibition on new administrative actions is going to have the effect of stopping that rule is an open question, and at the moment we'll find that out in the next few weeks.
Okay, moving along, identifying again the issues that plague dealers. Let's consider the used car rule. Failure to record the condition of the vehicle at the time of the sale, or just failure to use the Spanish language when required. ECOA, Federal Credit Opportunity Act. Failure to implement NADA's Fair Credit Compliance Policy, which addresses the disparate impact issue raised by the CFPB. Misrepresenting the applicant's income, misrepresenting the applicant's number of years employed. The Credit Practices Rule, failure to provide the cosigner notice when required, or using prohibited contract provisions such as confessions of judgment or wage assignment. Further problems with the Dodd-Frank Act, discriminating against discrete groups, minorities, overcharging fees for ancillary products, or the 4Ds that Richard Cordray likes to cite: discrimination, deception, dead ends, and debt traps. The Office of Foreign Asset Control, failure to check the list of the SDN, especially designated nationals. Federal Arbitration Act, using language which heavily favors the dealer. The language has to be balanced, so the equity between the parties, between the consumer and the dealer, should be maintained. Dave?
Next slide. As noted on the slide, any sentence that starts with misrepresenting or failure will get you in trouble. Let me give you a quick example. I was conducting a class recently in California, and I asked a question to the class. I said, what percentage of the credit applications do you have to increase the income on artificially to get a lender to accept that request for credit? Fellow raises his hand and says, about 20%. He got the question wrong, and he also got fired. You cannot misrepresent that. Keep in mind, the Fair Credit Reporting Act imposes specific standards regarding the accuracy and integrity of the information provided to a credit reporting agency. It is a felony at the state and federal levels to purposely misrepresent or knowingly allow the misrepresentation of the information on a credit application. Let's talk a little bit about risk mitigation tips in this area. As the dealer, you need to monitor the number of contracts submitted to a funding source that are rejected by it due to inconsistencies what was represented and what proves to be true. The lenders are much more aggressive today when it comes to calling customers directly to verify the representation submitted by the F&I person. Another good tip is to monitor your chargebacks, especially the short-term chargeback. Customer gets home and says, wow, I didn't know I bought one of these. They'll cancel it. The industry norm needs to be maintained where the chargeback should be 10% or less of the current F&I department income. Next slide, please. Credit Practices Rule deals with cosigners. We don't use those much anymore. The bank does not like cosigners. They make everybody co-buyers. which leads to straw transactions. Late fees then, or late charges, talk about when you can impose a late charge. Aside from abiding by them, make certain that your people are using the current documents. I'm not saying that institution-generated or privately produced documents are bad. However, what I can say is if you go to a major supplier, they have the legal staff to produce compliant forms that also satisfy the customer reading comprehension requirements. I know of a firm right now has a poorly drafted gap agreement, and it's an insurance company. They're paying lots of claims. Slide 22, please. Disparate pricing has been a CFPB hot topic. How the CFPB determines what constitutes a disparate practice is not germane to this discussion. However, I would recommend that every dealer incorporate a dealer participation rate modification form in their F&I office. JM&A has one, Route 1, DealerTrack, AFIP, and others. But I would even more strongly recommend the implementation of the NADA Fair Credit Compliance Policy and Program. It should be the industry norm. The best practice I can give you on this is to have a policy in place, a person designated to monitor it, and a means of documenting abidance with it and remedial action taken if things don't happen the way they're supposed to. Now, as it relates to the F&I markup on the sale, what regulators and consumer advocates don't want to recognize is that the selling dealer performs the installment sales funding origination duties on behalf of whoever accepts assignment of that contract. And the dealer has a right to be fairly reimbursed for the expenses incurred. However, these expenses must be within acceptable norms. As it relates to the CFPB's intent to ensure that consumers are getting a fair shake when it comes to aftermarket products, this initiative will likely remain in play. If not by the CFPB, it might be picked up by the FTC, but I don't think it's going to go away, Trump or not. The test will be, is the retail price paid for an aftermarket product, when added to the cost of credit to finance the retail price paid, commensurate with the value received? As it relates to shared risk insurance products, it will be difficult to assess. You pay $2,500 for a vehicle service contract, and it pays a $4,200 engine replacement. It was a prudent investment. If you file no claims, then what? It is likely that some of the peripheral products, say etch, may not make the cut. Here is my best practice advice on this, is that no product markup, aftermarket product, should be greater than keystoning. Keystoning is 100% markup over the wholesale price. This is an industry standard and should be defensible for certain core products. But again, none of this will work if you don't have a written policy, someone in charge of monitoring it, documenting the oversight, and making sure that you take action when required. Next slide, please. As Tom was saying about OFAC, that you don't have to OFAC everybody, but you cannot do business with somebody on the specially designated nationals or block persons list. Now, who does that include? Cash customers, finance customers, lease customers, body shop customers, mechanical repair customers, and your vendors. Now, you should set dollar thresholds for some of these. You don't want to have to run an OFAC check on somebody who gets their oil changed. But if you stopped at McDonald's on the way over here this morning, they should have run an OFAC check on you. What kind of protection does the OFAC accord car dealers? Zero. There is no statutory protection for a car dealer for not complying. However, if you fail to file the form, you can turn yourself in and get a 50% reduction in your base penalty. And as Tom mentioned earlier, the fines are excessive. If you knowingly sell a vehicle to a foreign drug trafficker, your maximum penalty is $5 million and 30 years in prison, or both. Again, written policy and oversight. The Caution and Arbitration Act is to make sure you have language in your agreement that was drafted by a qualified attorney. Sometimes it can lay dormant for a long period of time, and when tested, it has to be properly constructed for the dealer to have his defense.
Dave asked me to step in here a little bit with arbitration. One of the things that we do is deal jacket reviews, and very often we'll go in and take a look at an arbitration provision that's contained in a deal jacket, and it'll be old. And old arbitration agreements tend to not reflect developments that have taken place in the litigation in the last decade or so. Sometimes you'll see a reference to the arbitration organization, to an arbitration organization that's no longer in existence. Sometimes you'll see multiple arbitration agreements. You'll see a freestanding one in the retail installment agreement, one in the GAP agreement, one in the service contract agreement. If a judge sees a bunch of conflicting arbitration agreements in a particular transaction, the judge is likely not to enforce any of them. Another thing we see is that when we look at an arbitration agreement and it's been drafted by someone who has not kept up with the stuff that's going on in this area over the years, there won't be a prohibition against class relief. That's the most important thing to have in your arbitration agreement. And if that's not there, you might as well not have an arbitration agreement at all. The CFPB has studied arbitration agreements. They want to see ones that are, first they want them all to go away, but if they don't go away, they want to see ones that are fair and readable. So having somebody take a look at your arbitration agreement is a good idea. Next slide.
Yep. It's already up.
No, I did that one.
Modern class actions.
Yeah, I did that. Well, that's yeah. This slide Dave asked me to check in on the explanation I just went through about arbitration agreements. All that's in response to the modern class action rule. That's why that's at the top of this slide. The modern class action rule was the rule that gave rise to these class action lawsuits. That in turn gave rise to car dealers and others using arbitration agreements to defend against those. Okay, back in my normal role, I'm going to be talking about this set of laws. The Monroney label started off as a reasonably straightforward label on the side of the car. It required the disclosure of the car's MSRP, its engine and transmission specs, and warranty details. It's ballooned like everything else, like a kid's Santa list. Now it requires optional equipment and pricing, fuel economy information, crash testing information, and things like that. There's a lot on that Monroney label these days. The red flags rule. Again, this is a federal law that's intended to thwart identity theft. This is another example of the federal government deputizing car dealers and other businesses to help achieve a particular goal, in this case, identity theft. So every car dealer has to have a red flags policy. That red flags policy requires a red flags officer. The policy has to be written. It has to be periodically reviewed to make sure it's still working properly. That red flags officer, if you're smart, will also be your privacy officer and your compliance officer. The Fair Credit Reporting Act, dealers always wrinkle their brows when I start talking about their obligations under the Fair Credit Reporting Act. Why are they obligated to do anything? Well, dealers are creditors in the transactions in which they sell cars on credit using retail installment sales contracts. As creditors, they are obligated under the Fair Credit Reporting Act to do certain things and are prohibited from doing certain things under the Fair Credit Reporting Act. So you need a Fair Credit Reporting Act policy at your dealership to instruct your employees about what their obligations are. The Telephone Consumer Protection Act. I don't work in this area much, but several of my partners do. And this is relatively new stuff. It regulates communications with customers. There are prohibitions on the ways you can communicate with customers. You should especially be interested in this if you are either directly or through a vendor using any sort of communications devices in any sort of program, and especially if you're using auto dialers.
Okay, let's identify again some of the issues that dealers face regarding these laws. The Monroney label, failure to keep it posted, you have to keep it posted, or using a fraudulent addendum sticker which provides information which conflicts with Monroney label. The red flags rule, failure to appoint a compliance officer, failure to draft, implement, and update your identity theft program, and the emphasis should be on updating. And Thirdly, the failure to properly clear a red flag. How about FACRA, the Fair Credit Reporting Act? Misusing a credit report, misrepresenting a firm offer of credit. Dave?
Yes, let's talk a little bit about non-public personal information. In most cases, customer information stolen from your store is the work of amateurs. It's covered by the safeguards rule. Those individuals who typically purchase cars using a stolen identity are professionals, and they're good at it. Let's talk about some red flag rules compliance tips. Keep in mind that regardless of whoever conducts your red flag checks for you, you are required to have in your store a written identity theft prevention program under the direction of a formally appointed compliance officer. Also on red flags, the board of directors has to sign off on your initial and updated programs. Not required under safeguards, but it is red flags. Now let's do some risk mitigation tips. The best protection you can have against stolen identity is a 100% completed credit application. The more information you can collect from that customer and triangulate it against the information on their driver's license, insurance card, and the lender callback sheet with their credit report, the easier it is to detect, do you in fact have the customer as he purports to be. The second is to be aware of what we call Jack and the Beanstalk customer stories. Most identity thefts create some type of scenario that causes the F&I manager to deviate from his normal routine. My brother broke his back, we have to get the car out of the store today, whatever. Be wary of that. Number 3, if the deal doesn't look as it should be, get a manager involved. Get a second set of eyes on that transaction. And the last one is, if the F&I manager is not comfortable with the transaction, do not deliver the car. Next slide, please. The Fair Credit Reporting Act, risk mitigation practices. It used to be that you could run a credit report on somebody if there was an intent to buy. That has changed. You can only run a credit report on somebody now if there's been an overt act on the part of the customer to buy something. Asking the price of a car or going on a demo drive is not provocation enough. A signed buyer's order and a deposit, a signed credit app, those are things that certainly would make a difference. A firm offer of credit is a direct mail solicitation offering credit to customers who respond to the solicitation. You can finance a vehicle at our store if your FICO score is 650 or higher. And the mailing list was derived from Consumer Reports. Avoid these like the plague. If you want to get into a lawsuit, do a firm offer of credit ad. Let's talk about adverse action notice. This is the most abused federal policy that I know of. The purpose of this regulation deals with credit, not sending an adverse action notice to a customer just because the deal didn't get consummated is not necessary. Customer has a FICO score of 850, you send him a notice, he's going to call the dealership and not be happy. So what are the reasons why you can send the notice? Number 1, flat denial. The lender says, I am not buying this bandit no matter what. You send the notice. The second is, if the credit is conditioned as to substantially different terms or substantially different amounts requested and the customer does not agree with the qualification. I'll buy this with another $1,000 down. The customer says no, you send the notice. The notice can also be issued if the dealer does not have a credit source who will consider a request for credit below a specific credit score threshold. And the credit score for the customer applying for credit does not satisfy that threshold. Terry?
Okay, Tom?
This is our last set of laws and regulations. We've said a little bit about these earlier, so I'm going to speed through this slide. The first law is the Federal Odometer Act, again, 1972, a federal law designed to prohibit or discourage odometer fraud. Form 8300 cash reporting rule seems very simple. The dealer tells the IRS whenever he receives cash of $10,000 or more. Unfortunately it's more complicated than that, and those rules can get dicey. You need a written policy about how you handle cash. The modern class actions rule we talked about a minute ago, that's what led to the use by car dealers of arbitration agreements. The holder rule is a Federal Trade Commission rule that says that if a consumer has a claim or defense against you, the dealer, the consumer can assert that same claim or defense against anybody you sell that customer's retail installment contract to. So if a bank buys a retail installment contract from you, customer has a claim and defense against you, he can assert that claim or defense against the bank. Guess what's going to happen then? Bank's going to stick that contract back to you, put the problem back in your lap. The Magnuson-Moss Warranty Act requires disclosures of warranties, it requires you to label warranties in certain ways, and it restricts your ability to do as-is sales. The Federal Patriot Act is another anti-terrorist measure. This is another one of those laws where the federal government is deputizing car dealers to do its work for it. This is the source, by the way, of the suspicious activity report requirement. The FACTA disposal rule, this is part of the law governing consumer reports, part of the Fair Credit Reporting Act. There are specific requirements on how you must disclose of consumer information.
Okay, what are the infractions based upon what Tom just related to you? Considering the Federal Odometer Act, misrepresenting mileage, the IRS Form 8300 cash reporting rule, failure to file or complete properly the form itself, failure to properly comply with a voluntary suspicious transaction filing, the modern class action rule, failure to plan for class actions. That rule, by the way, provided that someone is automatically a member of a class. Prior to the passage of that rule, one had to opt into class action, so it made all the difference in the world. Further infractions, the holder rule, just failure to include it in the required document. The Magnuson-Moss Warranty Act, or the Mag-Moss Rule Act itself, limiting implied warranty without the appropriate notice, representing a vehicle service contract as an extended warranty. The Federal Patriot Act, failure to report cash in excess of $10,000 in a single transaction within a 12-month period, or two or more related transactions within a 24-hour period. Further infractions based upon these laws: FACTA, fair and accurate credit transactions act disposal rule, failure to dispose of non-public personal information properly, either electronic or actually on paper. The Can-Spam Act, misrepresenting the identity of the sender. Dave?
Yes, let's talk about the IRS 8300. You need to alert your F&I staff to the fact that the IRS loves to sting F&I departments. About once a quarter, I get a call from an F&I person reported the customer walked out of the store and saying that he wouldn't pay cash if the form would have been filed. That wasn't a customer, that was the IRS. Also, the IRS has added its emphasis on proper reporting of a TIN, a taxpayer identification number. They allowed some leeway in the past, driver's license, passport, whatever. They do not now. What is permissible is the taxpayer identification number, is the Social Security number, an individual taxpayer identification number, or an employer identification number for corporations, partnerships, and estates. Next slide, please. As it relates to F&I, per the Magnuson-Moss Warranty Act, Magnuson-Moss says the cost of a warranty has to be part of the bargain. You cannot sell a warranty. So when you return to your store, you might tell your F&I people to stop telling customers they're buying an extended warranty. There is no such a thing. You can't sell a warranty. What they sell are vehicle service contracts or extended service agreements. Next slide, please. The USA Patriot Act is an acronym. It stands for Uniting and Strengthening America by providing appropriate tools required to intercept and obstruct Terrorism Act of 2001. I just wanted to let you know how they spend your tax dollars in Washington. Again, Let's talk a little bit about the disposal rule. And the disposal rule is very specific as to the steps a dealer must take to hire a document destruction company. Let's talk about the CAN-SPAM Act, Controlling the Assault of Non-Solicited Pornography and Marketing Act. You got to love those acronyms. And what it deals with is the proper procedures in this situation for emails. But I want to digress for a second and talk about another do not, and that's the do not call rule. If your dealership has a bird dog program, somebody gives you the phone number of their next door neighbor, you cannot call that phone number unless you check that customer's name against the national and state do not call list. Now, I want to talk about a best practice in these regulations that works to your advantage, and we're going to go back to the CAN-SPAM Act. It is the email's subject line that determines how that transmission is regulated. And if you send a notice to your customers that say your car is ready in the shop to be picked up, that is a transactional message. It's designed to build on an existing relationship. So when you send an email to a customer saying your car is ready in the shop, that has to be the subject line. The body of that email has to be your shop hours are from 7 to 7, you take MasterCard and Visa and what have you. But if you do that, you can put a commercial message, an unsolicited email on the bottom of that transmission. We have tires for sale in the parts department, or your factory warranty is about to expire. See us about a vehicle service contract. What you can get is give yourself a free ride. Terry?
Okay, let's begin discussing some of the recommendations we have. I'd like to start out with the compliance management system. Franchise dealers are not under the jurisdiction of the CFPB directly. Great news, and that's due to the what the NADA did, and it's actually worth the amount of money your fees are to the NADA because of this action. But but it does apply. The CFPB has jurisdiction over buy or pay your dealers and certain independent dealers. And it requires them to have this compliance management system. And I think even though franchise dealers don't have an obligation to implement one, it makes good business sense. And here's why, because it consists of certain features. First of all, it requires a written compliance program, which is excellent to have so that you know about all the requirements of complying with the law. Secondly, you would establish a board of directors overseeing the compliance program. Secondly, you would appoint a permanent compliance officer. Now, as Tom stated earlier, the safeguards rule and the red flags rule requires you to have a compliance officer. We should have a compliance officer for all those compliance issues we've discussed with you. Thirdly, it requires the CMS or compliance management system requires a protocol for addressing consumer complaints. I'm going to guess, and it's a good guess because I have some experience in this area, 60-80% of all dealer problems emanate from consumer complaints. So if you're able to resolve consumer complaints, you're going to have far less problems from a legal standpoint. Treat those complaints like they're radioactive, that they are like ransom notes. That's how significant they are. So this system would already require you to have a complaint management system. And finally, you would have a routine audit of your program so that you're always updating it. Because remember, the laws that we're stating 100 years worth of compliance advice, it's dynamic, continues to change. So you would always want to update it as appropriate.
Okay, a few recommendations from me. You've got a compliance officer. That compliance officer needs to be someone who's trained and certified. You wouldn't think of having somebody down in the shop putting a transmission back together who had not been trained in transmission mechanics, and you don't want anybody on your who with compliance responsibilities who has not been trained. So get that person trained and certified. To fight payment packing, again, discuss all the products you offer with every customer. Maintain a menu log and make sure that all of that is properly documented. Your compliance officer needs to subscribe to every compliance and industry newspaper he or she can get their hands on. to make sure that they're staying abreast of the latest compliance developments. There are a lot of free sources of information. If you haven't been on the Federal Trade Commission's website, there are thousands and thousands and thousands of dollars worth of legal advice for absolutely nothing on the FTC's website. Especially interesting are the advertising provisions. A lot of good stuff there. Another great source of information that's not quite free but is close is the NADA's own website, where they offer various sorts of compliance manuals at very minimal cost. For $25 or $50, you can buy a manual on a compliance topic, and that manual would represent, if you had to pay for it, would represent several $1,000s worth of legal fees. Last, a lot of dealers rely on vendors for some aspects of their compliance. If you do that, make sure that you do your homework and get recommendations for that vendor. Make sure that vendor's on the up and up and knows what they're talking about. Next slide, Terry.
Okay, sure.
A few more recommendations. We've talked about adopting NADA's Fair Credit Compliance Policy and Program. NADA's is excellent. There are several other similar programs. Look at all of them. Pick the one that suits you best, but adopt one of them. NADA has recently put out an advertising guideline booklet that is terrific. One warning, it deals with federal advertising laws. Make sure that in addition to those federal advertising laws and rules, you also comply with your state advertising rules. We talked about signed menus. I won't do that again. Investing in ongoing training. Remember that these laws and regulations change. That's why my law firm is in business, frankly. Every day we get new developments. And when we get those new developments, the people who are trained, your compliance folks, need to be trained about what those new developments are. Protecting against rogue employees, doing background checks on people before you hire them, make sure they don't have criminal records or other black marks. And your document management procedures need to be in order. You don't want to be using a contract that's been out of date for 10 years.
Okay, further recommendations.
That's you, right? 40.
First of all, I'd recommend hiring an attorney who understands your business. The car business is unique. You need someone who understands the unique character of your operations and apply the appropriate law. If you don't have an attorney who understands your business, that person needs to be educated. If that's too difficult, find some attorney who is in that type of practice. Secondly, use a consultant. There are a lot of consultants here at the convention. Rely upon some of those people. Thirdly, beware of payment packing and the other common illegal practices. I spent 16 years in the Attorney General's office where I prosecuted car dealers and these types of issues. There are over 100 infractions that dealers should all be aware of, because some of these rogue employees show up, they could be doing something that is going to attract the attention of a regulator, cause legal problems. Address and document consumer complaints once again, consumer complaints are the number one issue. If you could get rid of those, you'd resolve a lot of your issues. The second is advertising. That's probably the other 20% of the issues you face. Make sure you get that correct. And finally, implement a current regulation-based training for your key personnel. As Tom just said, the law changes. You need to have people who are current with the current regulations. Dave?
Take a quick look at my slide, and let's get on then, because of time constraints, to predictions for the future.
Okay. Now comes the most interesting side of our whole presentation today, because we have Mr. Hudson here, our soothsayer, prophet, swami, and guru, who's going to predict the future. Mr. Hudson.
Okay, this is the part I hate, because at least half the things I predict never come true. Okay, let's see now. The first thing I see is a raise and promotion for Michelle. No, wait a minute. I'm looking at the wrong side. Let me. I've come up with about 9 things I think we're likely to see in the near upcoming future. The CFPB isn't going away despite everything you hear. We may end up with a 5-person commission. It may be somewhat less aggressive. It may be funded through Congress rather than through the Federal Reserve Board line item funding that it has now. It may be moved to a Department of Treasury, I don't know, something like that. But it's not going away. Its core mission is not going to change. We will not get rid of it. We will have to deal with CFPB in the future. The Federal Trade Commission is likely to remain as tough as it has been for the last year or two. I can't see any reason for it backing off, Most of the fire in Washington, D.C. has been directed at the CFPB, and not much has been directed at the FTC. So I think the FTC will continue to hound dealers, especially on advertising, but on spot deliveries, negative equity, and other issues they've been interested in. The proposed CFPB arbitration rule might get sidelined, might not, but might. If I had to bet, I'd say it probably will be held back, and that may be the one huge piece of news that we have coming in the next year or so in our area. State AGs are going to get more aggressive. We've seen that in New York already, but I think the state AGs from the blue states are likely to think the Republicans are slacking off on consumer compliance protection, and they're likely to ramp up their efforts some. I think the buy here, pay here industry is going to be weakened and a little bit smaller as a result of the CFPB's pounding on a particular buy here, pay here dealer last year in a very high profile case. I think we're likely to see them pull back a bit. That may give franchise dealers a little more room on the lower end of the credit scale. We'll see a continued press by the consumer advocates to require that creditors put into the APR and the finance charge the cost of things like vehicle service contracts and GAP and things like that. Under current law, those things are excluded. The consumer advocates want them included. That fight will continue. We will see an expansion of Service Member Civil Relief Act protections for our service members who are overseas, the ones who are in service. You've seen recent class actions about the repossession of automobiles of service members who are serving overseas. There'll be a lot of protective movements in that direction. The better dealers that we deal with, those better dealers are going to crank up their compliance efforts a bit over the next couple of years and begin to take compliance more seriously. But unfortunately, the dealers who got us into all these rules and regulations, the ones who misbehaved in the past, will also misbehave in the future. So we'll continue to see New York Times articles and LA Times articles about dealers doing bad stuff, and the regulators will continue to react to those like they always have. David?
Okay, now for a final word from Mr. Robertson.
We want to leave you with compliance advice that has been true for the past 100 years and will be true for the next 100 years. If the person whose name is on the sign believes their financial objectives can be achieved by treating customers equitably and in accordance with the law, provides the tools required to meet those objectives, and then hold those responsible accountable for meeting those standards, they will have taken the first and the most significant step towards being regulatory compliant.
Amen.
Thank you very much.